We ready to get started?
Yeah, you're you're
All right.
you're in charge.
Oh
Take it
well.
away.
All right. So try not to panic anybody by the time we get to the other end here. Um, yes, I'm David Cash, Associate Director of Risk Management at PRMS. Have to do a couple of disclaimers. We'll talk about some cases and legal concepts today, but nothing I say should be construed as legal advice. I'm admitted in Maryland, not in New York. So if you need actual legal advice, seek competent counsel, and by competent I mean not me, at least not in New York. And I have objectives here, but it's not CME, so we don't have to dwell on those. So starting with just a little levity as we go through, there are tons and tons of social media platforms for various purposes. It's hard to know exactly where to start. It's almost like you have endless options today. But here are the risks that are really common to all of them. These are your exposures, and we've seen pretty much weekly examples of each of these. When something goes wrong, it can range from you know something funny to something disastrous. And unfortunately, by the time it gets to us, it's usually the disaster cases. So, in terms of these specific exposures and how they play out, you can certainly face a claim, which is a written demand for money short of a lawsuit being filed. So, let's say you have a private practice and your practice has a Facebook page. One of your staff members has been tasked with managing the Facebook page. And one day, the staff member uses a Facebook profile to like a post made by one of your patients. So your patient calls and it's upset. And to compensate him for this inappropriate disclosure, he's demanding that you write off his next 3 appointments and his outstanding balance. So that's technically a claim, and it implicates vicarious liability because as the employer, you're actually responsible for the actions of that employee. The risk management advice is to have policies and procedures in place and train your staff not to make postings like this. You do that and document that training, and you'll likely be immune from suit if this became a suit. Then you also face a couple of types of litigation. The first is a civil suit. Um, in one case, we've had a woman sued her psychiatrist, medical school, and a hospital after she was admitted to the hospital for extreme intoxication. And one of the doctors took photos of her and posted them to social media sites with commentary on her condition. Um, the physician was a fellow who happened to be in the hospital, but he was not a part of her treatment team. And actually knew the woman, the psychiatrist rather, and actually knew the woman through a mutual friend. She wound up suing the hospital for $1.5 million, claiming an invasion of privacy and infliction of emotional distress. So a few years ago, it seems like nursing homes often wind up being on the receiving end of a complaint. In the last few years, there have been many reports of nursing home staff members posting embarrassing and really dehumanizing photos of elderly residents on social media. In one of the cases, a nursing assistant posted a Snapchat video of an 85-year-old dementia patient naked in the shower while staff sprayed her with water. The caption says she hates showers. And when she was confronted, the aide who posted the photo reportedly told her supervisor she meant to take a photo of just the woman's face. I'm not sure how that's any better to show to other employees, and accidentally posted it on her public Snapchat feed. And this nursing assistant was charged with a felony count of taking a nude photo without consent and pled guilty in 2017 and received 180 days of home detention as well as 1 year of probation. So it's kind of got off a little bit easy, but in a lot of cases involving elderly patients, charges have been brought for elder abuse or for failure to report elder abuse. So we move, here's the photo, coverage of the photo when it was posted. We move from litigation to administrative actions. You could be the subject of a licensing board complaint, as well as an enforcement action by OCR, the Office of Civil Rights, for a Hipaa violation. So medical boards care about what happens on social media. They have an interest in it. And in 2012, this research letter was published in the Journal of the American Medical Association. So in coordination with the Federation of State Medical Boards, that's the trade organization. I believe every state medical board and osteopath board is a member of the organization. So they talk to each other. In coordination with FSMB, the authors surveyed the member licensing boards to determine exactly what the boards were doing in terms of complaints of online misconduct. And of the boards that responded, 92% of them reported having seen at least one complaint of online professional misconduct. 71% reported holding disciplinary proceedings. And the most common allegations were inappropriate contact, sexual misconduct online, basically, inappropriate prescribing online, and a misrepresentation of credentials. And in these cases, it wasn't just patients and their families filing the complaints. 50% of the complaints were filed by other physicians. So physicians can be disciplined for online behaviors such as those you see here. These sorts of behaviors are like well publicized. So we have a second study. This is a hypothetical study. Well, it was actually a real study, but it was based on hypotheticals. So the medical boards that were polled were given descriptive behavior and asked whether they would be likely or very likely to investigate that physician. And of course, from the last study, some things you would present or expect rather, citing misleading information about clinical outcomes, misrepresenting credentials, and so forth. But a couple were a little bit of a surprise, showing alcohol use without intoxication, right? So you think the next time you're at the fundraiser for the hospital, holding a glass of wine, and somebody snaps a picture and posts it on the hospital webpage, 40% of medical boards said that they would be likely or very likely to investigate that physician. So they're people take this very, very seriously, both medical boards and law enforcement and the courts. There was an attorney in the DC area who was disciplined recently. He was representing a client in a criminal matter, and the client's behavior was well documented pictorially on his Facebook page. So the attorney just told his client, before we go to trial, you need to clean up your Facebook page. Well, when all the material disappeared, which I assume the prosecutor had been looking at, questions got asked. When it came out that what the attorney had advised his client, the attorney got sanctioned for counseling his client to destroy evidence. So courts very much take social media seriously, along with licensing boards, employers, and so forth. So when in this case example, a physician was suspended by his hospital for professional misconduct after becoming aware that he was posting, basically venting his spleen about his job on Twitter. The hospital notified the New Jersey Medical Board, so the board investigated and found that the doctor had tweeted under several names, went by the name Dr. Kill Patient. So during his disciplinary hearing, he testified he had tweeted a couple of thousand times, with 60% of those tweets related to his job. He used dark, humorous stories related to unidentified patients, and so he could vent his frustrations. He was also blogging on 2 websites. Ultimately, the board found that many of his tweets appeared to ridicule ED patients or referenced the stressful environment. And he also admitted in his hearing of posting photos of patients. So he was reprimanded for professional misconduct, required to take a HIPAA refresher course, pay a $500 fine, and I think he also kind of got off easy for that. So OCR, an action from OCR to enforce HIPAA is the next exposure. So a lot of times HIPAA violations or breaches of confidentiality via the internet, those get investigated by OCR. So one medical practice became familiar. There's the hard way. They set up a platform on their website as a surgical practice. So patients could book their own appointments and surgeries, which was, very convenient for patients. Unfortunately, they didn't realize that the scheduling system was publicly accessible. So patient names, diagnoses, the procedures they were having were all visible for others to see, including non-patients. So that practice paid $100,000 to settle that investigation. And an ethics investigation is also a possibility by professional organizations like the APA, also by your hospital, for mishandling patient information online. There can also be professional consequences like loss of privileges. The doctor I mentioned earlier that went by the name Dr. Kill Patient lost his hospital privileges as a result of his blogging and venting his spleen. So, and then one nursing student we know of from the literature was expelled from her training program because she blogged about the details of a woman's delivery during her OB rotation. And she didn't even name patient names, but she gave enough detail so family members could identify the patient. She fought the expulsion in court, but the court upheld it based on our details of the post and the confidentiality agreement that she had signed with her nursing program. So with that, looking at our exposures, we can dig a little deeper and look at your personal use for social media and how that might put you at risk. Our suggestions are really to separate personal and professional pages and not accept friend requests, of course, from patients. This is from the Federation of State Medical Boards. Part of what they do is write model legislation that member medical boards and position statements and so forth, member medical boards can take those back to their home states, and some of them enact them word for word, some of them modify and enact them. So they said in their model policy guidelines for appropriate social media use, physicians should only have online interaction with patients when discussing the patient's medical treatment within the physician-patient relationship, and these interactions should never occur on a personal social networking or social media website. So, consider making your account unsearchable. And with, with Facebook, a lot of times it's not so much your page, your Facebook page, but it's your friend's Facebook page because, people can see your friend list and visit them. So you may have to ask friends to take posts down if they're not really appropriate. Don't use a photo for your profile or make your profile photo private. Only friends should access your friends list, and again, ask close family members to take your professional stature in the community into account with their posts. There is, of course, no anonymity. For psychiatrists, this comes up a lot. This is kind of conservative risk management advice, but I look at it as, in psychiatry, the stories belong to the patient. So even if you're publishing their story and it's not properly authorized, you're basically identifying them and stealing their information to post online if it's not authorized by the patient. So it's important not to blur boundaries. Of course, if you receive a friend request from a patient, you can ignore it and address it in the next session that you have with the patient. So there was some things can get really weird with social media. There was a psychiatrist, I think this was probably published in the New York Times. We'll just call her Lisa. She was an infrequent Facebook user, but the summer before the article was published, she noticed that her social network, and I believe it was Facebook, had started recommending patients as friends, and she didn't know why. She hadn't shared her email or phone contacts with Facebook at all. And then things started getting weirder because she was a geriatric psychiatrist. So all of her patients were senior citizens, but she had one outlier, a 30-something snowboarder. So usually Facebook would recommend he friend people his own age, people who liked snowboarding and jumping out of airplanes like he did. But the psychiatrist told this reporter that her patient, her 30-year-old patient, had started seeing friend requests from older and infirm people, like the 70-year-old gentleman with a walker or somebody with CP. And he shared this with Lisa and kind of laughed it off and said, I don't know any of these people who showed up on my list. I'm guessing they see you. So to her horror, he shows her the list of recommended friends, and she sees names of her patients. So she got a chance to practice her poker face, so she didn't confirm that any of them were patients. And what turned out to have happened was at some point, Dr. Lisa had given Facebook her cell phone number, and that's the number that patients also had in their phone. So Facebook, of course, matched those two up and created a people you may know list and disseminated that around. So it's important to understand the inner workings of whatever platform that you are using, and be wary of allowing them to suggest friends. And because you are human and allowed to have a personal life, we occasionally get a situation where the psychiatrist is on Match.com or eHarmony and so forth. And every once in a while, it's small worlds out there. Every once in a while, a patient and the psychiatrist bump into each other. So we had one case that we had to, I think we got multiple lawyers and IT people to kind of disentangle the psychiatrist. One of our insureds accepted a friend request from a person he didn't know. And it turns out that friend request came from a fake account that was created by his patient. And then boom, the patient's in, the patient could see his whole profile. The patient then made a duplicate account and started to send friend requests to all of the psychiatrist's Facebook friends. It was a real mess. We had to get a whole bunch of people involved to get the psychiatrist out of that. We also got a call from one of our insureds a couple of years ago. He was looking for risk management advice. He was calling to discuss whether he made the right decision in terminating treatment with a longtime patient. The patient had borderline issues, and the patient had recently started asking questions about the psychiatrist's personal life. And it just became clear that this patient knew things about the doctor that he had never and would never disclose. The doctor did have a personal Facebook account, but he was certain that the patient hadn't accessed his profile because he didn't have a picture on his profile. His pictures were private and his wall was private. Well, turns out the patient had indeed accessed his account. The patient searched his name and then began combing through any individual with the same name in the city to see what information was available on the doctor. Unfortunately, the doctor forgot to make his friends list private, and that's where the patient found a woman believed to be his wife. His wife's profile was public, and then the patient's in. She's got photo albums of inside their home, the family on vacation, and so forth. So we had, there's some horror stories in this where, but usually inadvertent, when oftentimes patients, as well as the psychiatrist, don't use their full name or real name on some of these sites, and don't have a photo, which we recommend considering not having. But if you're on a dating site, assume you'll be seen by patients, assume you'll be seen by someone from your medical board, and be careful who you reveal information to. All right, let's talk about social media in your medical practice. Again, I've mentioned the model policy and guidelines from the Federation of State Medical Boards, and these have not been enacted by that many states. New York is very quiet on social media in medical practices, but if this is still, I think, a good resource, whether it's been enacted by your state or not. And then just the North Carolina Medical Board has, they have a great collection of rules and positions, and it is a good read, and they usually write pretty well. So they're one of the minority of states that has actually written on professional use of social media. The AMA has also written on the use of social media. They recommend maintaining patient privacy and confidentiality, refrain from posting identifiable patient information, and that's almost everything. One of our insureds from Rhode Island was disciplined by her medical board because she posted, actually, it was a pretty good post, it was educational, on her Facebook page, and patient and family recognized the story. She got sanctioned by her medical board. So we see those stories, even when they're well-meaning posts. And of course, the AMA recommends separate and professional content online, and keeping those separate. And once you're on the internet, it's whatever you post is there forever. Essentially, sometimes the zombie posts come back to haunt you where you think you've deleted them. If you do have a Facebook type page for social media, we recommend not allowing patients to post. Even liking a post, as we saw from the earlier case, may be a breach of confidentiality, because it's in most instances are going to wind up confirming that person is a patient. And absolutely no photos. And I would say, I would suggest don't posting patient photos even with consent. I mean, it's in psychiatry, it's typically just not worth it to post a patient's photo. And then, maintain control where you have a professional Facebook page over what employees can post, who has access to the Facebook page. And every once in a while, we recommend checking, just Googling your name, checking your online footprint, because a lot of services are out there that set up social media pages for you. So you may have a social media page and not realize it. So for professional use, remember that there's more to de-identifying patients than changing their name. If they can recognize the story, they'll have enough to support a complaint against you. It's best if you review comments. If you're going to have a public forum, don't slander, vent your spleen. Consider private tweets if that's more important. And disclaim that any treatment relationship exists, so that nothing you're writing is intended to be medical advice. And then walk that walk. I mean, you can disclaim all day long, but if you actually give medical advice, your disclaimer is really not gonna work. And then a few years ago, after the during the 2016 election, the Goldwater Rule got like renewed attention. And of course, you know that it's ethically prohibited, basically, from rendering a professional opinion about a non-patient in the public light with a specific diagnosis or prognosis. You're not prohibited from educating the public, but you can't make that diagnosis or comment on public figures. And a few years ago, my boss, Donna, wrote an article called Pause Before Posting. I always thought this was excellent advice. Part of the downside of social media is it's instantaneous. You know, you hit that post button and, you know, it's out there. So in one of the stories she focused on, the Cleveland Clinic, their medical director basically went online on his online column and bashed vaccines. And this didn't go over well with anybody, not his colleagues, not the clinic, his patients, or the public. You know, he tried to apologize by saying he fully supports vaccination, but, you know, needless to say, he's no longer works at the Cleveland Clinic, unfortunately. So definitely pause before posting. Before you post, go through this checklist. Assume your patients, your employer, your employees, an ethics committee, your licensing board, and any attorney representing a plaintiff thinking about suing you. You should be okay with all of those folks, seeing your post. So there are online physician communities that are out there where supposedly everyone in them is all physicians and, you know, supposed to support discussing cases and so forth. So it's basically the online version of a curbside consult. So we don't like these that much because we find a lot of times the MD/JD type, the physician attorney or the expert witness, wind up being online and listening to everything that you say, basically. So you still have the potential for a privacy breach. So, you know, use the minimum necessary if you're going to take advantage of the curbside consult kind of function. But you know, consider whether, you know, maybe an email to one of the other members, kind of a one-on-one, isn't more appropriate. Listservs are typically private, but information can be forwarded. So as with any case, you know, maintain confidences. These listservs, even though they're private, they're discoverable in litigation. Same with social media websites. And, you know, frame your discussion around informal consult versus treatment advice, because you never know who's on there. If you're giving supposedly consult to a non-physician, sometimes I mean, the most important indicia of a consult is the other person is free to accept or reject your advice. That's what keeps it low risk for you as the consultant, the person providing the consultation. But if you're talking to, in reality, a non-physician, it looks less likely that that person is maybe really that free to reject your advice that can be construed easily as treatment advice. And then rating sites. These are the bane of my existence in the office right now. It always seems like it's the patient that the psychiatrist has bent over backwards to help that turns around and posts a poor or bad review. So we get a lot of calls in this area. So the risk management advice is to try to resolve the issue with a patient. And if there's a kernel of truth to the post. The patient may be willing to take it down or update it. If information is patently false, you can ask the site to remove a post. You can ask them. Some sites will remove a certain number of negative posts. I think one of them would remove 3 negative posts, and I suppose after that you're kind of on your own. But the way the law has evolved, sites are pretty much immune from postings of third-party reviewers. So we suggest not wasting money on reputation monitors. They usually don't. It's been our experience. They don't do much good. And then a couple of things, a couple of never things. You can't trade confidentiality for an agreement from patients not to post a bad review, and you can't astroturf. We'll talk about those 2 things. And it's helpful. You can control the conversation about you. So this dental practice paid $10,000 and had to come up with a corrective plan because they posted responses to Yelp reviews, and there were quite a few of them. One person complained, but OCR found a whole bunch of them, and they wound up getting fined for that. So this is the trading confidentiality for not posting a negative review. This practice, when patients came in as new patients, they would have the patient sign an agreement not to comment negatively about the physician or the practice, and in exchange, the physician would comply with Hipaa's privacy rule. Well, eventually a Hipaa complaint was filed on that, and no surprise, OCR came in and pointed out that your obligations under Hipaa are separate and distinct and can't be used as any sort of bargaining chip to buy a patient's silence. And in this case, this is a New York case. I think for years, the Attorney General's office in New York has been pretty actively enforcing some of the shenanigans that go on the internet. They have a whole bunch of similar cases to this one. In this case, it was one of those med-spa kinds of practices. I think they're based on Long Island somewhere. And what the plastic surgeon that was involved in the practice wanted to push down negative reviews, because when you get positive reviews, the negative ones fall to the bottom of the list, so they're not as readily read by visitors to the website. So this guy got employees on the clock to go online and post positive reviews, fake positive reviews, to push the negative reviews down. And the Attorney General did not take a shine to that. I think it's probably unlawful in New York. One of our panel attorneys was telling me to impersonate somebody else like that. So the practice got fined $300,000 for that approach, astroturfing, they call it. So another plastic surgeon, I don't know what it is with plastic surgeons, but another plastic surgeon whose case we know about took a less subtle approach. After there was a negative online post after a body contouring procedure, the surgeon retaliated against the patient by uploading a video of the patient in her underwear to YouTube and Facebook. The surgeon also sent an email that said, "I will damage your professional reputation and you will be humiliated." So, of course, the patient files a complaint with the surgeon's licensing board for professional misconduct. She also filed a complaint with OCR for the Hipaa violation. She had just never consented to a video at all, much less posting it on social media. So the physician's board, she was from Texas, had to take Texas medical jurisprudence exam, 24 hours of CME, including 8 hours on Hipaa, and pay a $2,000 penalty. And we don't know how the case turned out, but the patient also winded up suing the physician. So vicarious liability or respondeat superior, that's just the legal concept that says an employer is responsible for the acts of the employee. And that the employee has to be working in the course of his or her employment. And that's where some of the cases that we talk about where the employee posts patient information on social media, where there's a policy or procedure, where there's up-to-date Hipaa training, a confidentiality agreement, all those things are the risk management. Because if the employee steps out of the course of their employment to post something on social media, despite having been trained and warned not to, that can save a practice. It can save a hospital too, if that training is in place. So, you know, one case example of a vicarious liability case in this area was a patient had learned that she contracted a sexually transmitted disease from a new sex partner other than her husband. The employee told another employee about this, who told others, including the patient's husband. Then somebody created a MySpace page, and yes, it's an old case, posting the medical information, because unless you have a band, I don't think you're on MySpace anymore. So the information got posted. A picture of the patient was posted, along with comments about her cheating on her husband and her addiction to plastic surgery. The page was titled Rotten Candy. So the clinic, as well as all the actors that were involved, were sued. And the appellate court said, you know, this does constitute an invasion of privacy, but the defendants tried to say that the MySpace page wasn't publicized because it wasn't proved that more than a few people saw it. The court just dismissed that argument right out of hand. Unfortunately, the clinic was dragged into the suit because of the actions of this rogue employee, but the clinic got lucky because there, one, wasn't enough evidence to really determine who created the page, and the employees were acting outside of their job description when they did this. So for VL, again, recognize as a potential exposure for you. Create a social media policy for your practice if you're going to use it, and educate staff on the policy, and limit the number of people in your office who can access those accounts. Googling patients. You know, think about, have you ever Googled a patient before for whatever reason? The APA has opined that Googling is not unethical, but it should only be done in the interest of promoting patient care, basically. So I always like to ask, what would you do if you you Googled a patient and found out that he had sued his last 5 psychiatrists, right? So sessions from that point on are going to be potentially uncomfortable with everybody walking on eggshells. So you know, just think about why you Google a patient. And there are plenty of legitimate reasons to, but it shouldn't be for voyeuristic interests. And then practice websites can be a great way to really get some efficiency in your operation. A lot of folks like having forms online that patients can download and fill out so they're ready to go at that initial session. And the low-risk practice websites are those that don't have any communication platform, like the patient can't email you from the practice website. It's very easy to inadvertently give treatment advice or prematurely establish a treatment relationship through those interactions. So a practice website that's even educational, but you know, talks about your clinical approaches, hours, location information, and so forth, is a low-risk practice website. The more interactive it is, the more you risk again, inadvertently establishing a treatment relationship with a patient. Online referral services can be a great help to your practice too. We've noticed that some of these tend to attract drug seekers. So my colleague Ann McNary came up with a good approach. She said that, add statements to your profile that, maybe the first visit is for evaluation only. You check the iStop database, you don't prescribe controlled substances on the first visit and so forth. And we think that's had some effect in helping cut down the number of patients who are using referral sites to doctor shop, basically. So we talked up to this point about things that doctors do but shouldn't be doing. So, but it's not all, doctors. There's also patient use of social media. And, you may want to consider inquiring about, in an appropriate sort of way, about a patient's online habits. You think about what patients can and do online. They can bully and be bullied, and that's obviously a concern for you. We know Instagram has a massive harassment program, and there probably is a tie between adolescent suicide attempts and bullying. So you may want to know if your patient is bullying or being bullied. Patients can also research dangerous behaviors. This young woman suicided online in a virtual forum. It was a suicide support group, not helping people not commit suicide. It was a pro-suicide support group, and they view every death as a win, basically. So if you're treating this patient for depression, and this is her social support network, you may be flying blind into some challenges in treating her if you don't know this is what she's doing online. And there's even the mighty Yahoo answers the questions how to suicide painlessly and easily. So here are just my final thoughts, so have time for questions. Technology doesn't change your obligation to maintain boundaries or any other obligation. Use high privacy settings, don't accept friend requests from patients, and really the acid test. Assume what you post, your esteemed colleagues, employers, your licensing board, your patients are all going to see what you're posting. So pause before you post and see if you're comfortable with others seeing that post. Any and all content is potentially discoverable in litigation. There's no such thing as anonymity. And then recognize the potential exposure for the acts of your employees. Always have the saying, employees typically get in trouble for Facebook posts. Physicians, psychiatrists often get in trouble for blogs and their writings online. And then if you are a covered entity under HIPAA in your private practice, you should be having annual HIPAA training, and the appropriateness of social media and your policies should be included in that training. And then if you do have a professional page, limit who can access it. And it's okay to Google patients, but you should have a clinical purpose in mind of doing that. And every once in a while, Google yourself or run your own name through a search engine so that you can keep up with what's being said about you. And then consider how your patients may be using social media. And you may want to inquire as to what sites they're visiting. All right, that's what I have. Let me open it up for questions. Oh, I have one comment. That's terrifying. Yes, yes, sometimes yes.
I mean, I have to say that since I've attended these talks starting from when I was a resident, that I barely use social media now.
Right.
You guys have scared me into minimal contact with my friends and family from long ago. Just little facetious, but not really. Um, but I want to add that it's not just clinical things that get folks in trouble, and it's or substances. There's one anecdote that was in the media recently, that I just want to point out that, and it's very, I think, apropos of the times. The resident from Cleveland that made anti-Semitic comments in her social media, and she was um, not quick to lose her privileges, but she lost her privileges, and then apparently even went on to then lie about her CV and obtain a new residency before then being rediscovered and banned. But your actions can be devastating to your career, um, no matter what stage of your career that you're in, and you have to be very thoughtful about how you present yourself. And I'm aware of the irony in saying this when certain people in the current administration perhaps don't follow those same rules. We are held to as physicians and nurses and social workers, we are held to a higher standard, perhaps.
Yeah, there's a comment. I was talking about the algorithm Facebook had to suggest friends. Where do you see that this accumulation of big data and predictive algorithms might take us in terms of potential other dangers for providers? Oh, the sky's the limit. I mean, we see already, it's a long-standing practice. If you have, some of the free electronic health record products, your information, well, I'll put it this way, free is not a viable business model. So, or at least not for long. So you can bet those folks are aggregating your data, probably yours and or your patients, and selling it. So I think a lot of times free for me is like a warning flag that something's going on here. I want to know how my data is being used, how my identity is being used, because somebody is doing something behind the scenes. So, and we're likely to see more of these. Social media sites have proliferated over the last decade. Just as a show of hands, I think I can see most of you. Um, how many of you have a Facebook page, personal? I do. I have to admit I do. And what about, we are probably not practicing yet, but if you've practiced before, have you ever been in a practice that's had a professional Facebook page? No, I'm not seeing any hands. Good.
I don't even know. I don't know if I have a Facebook page or not. Um, what 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 troubles me about some of the social media is that sometimes people that say things that I am not in agreement with appear on my somehow my people that I know get those messages. And so I've had to delete people when they've come up. I get a lot of Facebook things. I don't know if I have a Facebook page.
You can Google yourself and
Oh, I do, but I don't know if I have a Facebook page.
I think Facebook usually scores pretty high on search engines. If so, in all likelihood, it would have come up.
It will come up and say I'm on Facebook.
Yeah, you'll see. Well, you'll see a link to Facebook.
Oh, okay, I'll have to look.
Yeah, yeah. Let's see. During COVID, there was a suspension of the use of HIPAA non-compliant technologies for provider communication. I'm glad somebody asked this. The short answer is yes. You were allowed to use platforms that weren't necessarily HIPAA compliant. I think everybody realized a lot of patients got stranded. You see a patient in college, all those dorms emptied and patients scatter everywhere. So there were a lot of waivers for the COVID public health emergency. And I believe the non-HIPAA compliant technology, I think that's still in effect. But the reason I'm glad that you brought this up, because I want to give you two resources. And the first one is absolutely for that. If you we're tracking all of those waivers and changes. So if you go to prms.com/FAQ, we're tracking all the state waivers, their state licensure waiver information, and we're basically that it gets printed. Or it gets printed all together state by state. So there's an example. So if you have a patient stuck somewhere, you can look it up. We're updating this typically daily.
Oh.
So that's there. And I believe, yes, that the waiver is still in effect. So, and I had a thought on those waivers because I know some folks are out there, and patients too, because patients are savvy on these waivers. If a patient is doctor shopping, they know they can call a greater number of doctors, maybe across state lines, to try to become a patient and take advantage of the situation. But my thought on all these waivers, at some point, they're going to go away. And you run the risk of having established a treatment relationship with somebody you can no longer treat once the waiver's gone. So my thinking through the COVID situation, if you need to take advantage of a waiver because a patient is stranded, absolutely, take care of the patient first. But if it's possible to set up like a telepsychiatry practice and not rely on that waiver and use FaceTime to meet with the patient or something, it's better to do it right, even though the waiver's out there. The other thing that I wanted to invite you to join was prmsu.com. This is our CME platform. So what happens is if you're a resident fellow training director, you can access this for free. It's going to ask you, when you register for the first time, it's going to ask you basically email, your name, and when you finish your program. At some point, probably a year after you're done, we're going to turn off the login credential. But while you're in residency or fellowship, you're welcome to visit this site. Usually as residents, you don't need CME. But you can take the CME if you'd like, and all of our white papers and so forth are on here, our articles, newsletters, our monthly podcast. So help yourself to that page.
I just one addition in regarding the HIPAA compliance and telemedicine during the pandemic. I mean, just a reminder that those protections were put in place for a reason, right? That there are reasons those data security protocols are mandated, and though there have been exceptions in our clinic, we have opted to not use any technologies that are not HIPAA compliant because we value that security for our patients. Right. And even if you may somehow be accepted from some degree of legal culpability, if there is a breach, there are ways, there may be civil liabilities, right, or other liabilities which can accrue.
Yep, HIPAA inform, even if you're not a covered entity and technically don't have to comply with it, HIPAA is used by courts to inform the standard of care for handling patient information. So even if OCR can't enforce an action against you or come and get you, those standards can still be applied to you. It's really a floor of how to protect patient information. There, as an aside, there are also kind of the long arm of the law. There are a lot of situations like that. I'm thinking about a psychiatrist who was disciplined. I want to say Washington State, but I'm not certain about that. Basically, she did forensic work, and she violated a court's gag order and got in trouble with the court and got disciplined. And they held the ethical standards of the American Academy of Psychiatry and the Law against her. Only she wasn't a member of Apple. She raised that point. The court said, you know, nothing doing. You did forensic work. This is the ethical guideline that you're supposed to be following. So there are a lot of situations like that.
I'm mindful of everyone's time, but were there other trainee questions? This is time with risk management specialist is extraordinarily valuable.
We've answered every question. Let me leave on a high note, because I know a couple of people said that this is terrifying. Let me just reassure you that you guys do a great job of risk management just by going into psychiatry. Psychiatry is a low-risk profession. Not even that. It is the lowest risk medical specialty. So it's actually for a lot of reasons. So even if you do face a claim or lawsuit, odds are in your favor of prevailing. So just keep up the good work, keep doing what you're doing, and it's actually very difficult to successfully sue a psychiatrist.